meetings of stockholders or members and directors or trustees.
Stockholders or members' meetings may either be regular or special. The regular meeting of stockholders or members is held annually on a date fixed in the bylaws or on any date after April 15 of every year as determined by the Board of Directors or Trustees. While the special meeting of the stockholders or members is held at any time deemed necessary or as provided in the bylaws. With respect to notice, a written notice shall be sent to stockholders or members at least 21 days prior to meeting, unless a different period is required in the bylaws, law, or regulation. While in special meeting, at least 1 week written notice shall be sent. Remember the rules: at least 21 days prior to meeting in case of regular meeting, and at least 1 week written notice prior to meeting in case of special meeting. In both cases, in case of postponement, notice shall be sent at least 2 weeks prior to the date of the meeting, unless a different period is provided.
Stockholders or members' meetings, whether regular or special, shall be held in the principal office of the corporation as set forth in the Articles of Incorporation, or, if not practicable, in the city or municipality where the principal office of the corporation is located, provided that any city or municipality in Metro Manila, Metro Cebu, Metro Davao, and other metropolitan areas shall, for purposes of the law, be considered a city or municipality. I would like to call your attention and correlate Section 50 from that of Section 92 of RA 11232. In Section 92, this is with respect to the place of meetings for members of non-stock corporation. The bylaws may provide that the members of a non-stock corporation may hold their regular or special meetings at any place, even outside the place where the principal office of the corporation is located, provided that proper notice is sent to all members, indicating the date, time, and place of the meeting. Provided further that the place of meeting shall be within Philippine territory. The quorum required for meetings of stockholders or members: the stockholders representing majority of the outstanding capital stock or majority of the members under Section 51. The notice sent by electronic mail is already allowed under the SEC guidelines. Notice of meeting may be waived. However, general waivers of notice in the Articles of Incorporation or bylaws shall not be allowed. Attendance at a meeting shall constitute a waiver of notice of such meeting, except when the person attends a meeting for the express purpose of objecting to the transaction of any business because the meeting is not lawfully called or convened. The stock or transfer book shall be closed at least 20 days for regular meetings and 7 days for special meetings before the scheduled date of the meeting. All the proceedings and any business transacted at a meeting of the stockholders or members, if within the powers or authority of the corporation, shall be valid, even if the meeting is improperly held or called, provided all the stockholders or members are present or duly represented at the meeting, and not one of them expressly states at the beginning of the meeting that the purpose of their attendance is to object to the transaction of any business because the meeting is not lawfully called or convened.
Problem. The Board of Directors of Fascinated Inc. approved its plan of merger with Deluxe Corporation. A special meeting for the stockholders was scheduled for the approval of the merger. Due to time constraint, a notice was only sent via email on April 27, 2019, or 3 days prior to the scheduled meeting on April 30, 2019 at 4 p.m. in Manila Hotel. Joaquin De Leon, stockholder, personally attended the meeting without manifesting his objection. It was only after 3 days that he opposed the approval of merger made by the stockholders. He questioned the validity of the meeting and argued that the principal office of the corporation is located at Pacific Tower, Makati City, and the urgent notice, which was sent through electronic data message. Is the stockholders meeting for the approval of the plan of merger valid and in compliance with the law? Choices. Letter A. Yes, the notice of meeting can be made through electronic message at any time prior to the scheduled date and anywhere at the discretion of the stockholders. Letter B. No, the notice for special meeting of stockholders should be made 1 week prior to the scheduled date of meeting. Letter C. No, because the meeting was not held at the place of the principal office of the corporation. And letter D. Yes, the notice of meeting can be waived when the stockholder attended a meeting without raising his objection, and the meeting held in Manila is valid since it was held within Metro Manila. How do we answer? Sending of notice of meeting via email is already allowed under the guidelines. And sending of written notice in a special meeting should be made 1 week prior to the scheduled meeting. Nevertheless, the sending of notice of meeting can be subject of waiver if the stockholder attended the meeting without raising his objection. In this case, at the time that Joaquin De Leon attended the scheduled meeting, he did not raise his objection. The place where the meeting was held in Manila Hotel is likewise valid because it is located within Metro Manila. Our answer, letter D. Yes, the notice of meeting can be waived when the stockholder attended the meeting without raising his objection, and the meeting held in Manila is valid since it was held within Metro Manila. Directors or trustees meetings may either be regular or special meeting. The regular meeting is held monthly unless the bylaws provide otherwise. In case of special meeting, this is held at any time upon call of the President or as provided in the bylaws. In both cases, the regular or special meeting may be held anywhere in or outside of the Philippines unless the bylaws provide otherwise. Written notice must be sent to every director or trustee at least 2 days prior to the scheduled meeting unless a longer time is provided in the bylaws. This may be exercised through remote communication such as video conferencing, teleconferencing, or alternative modes of communication. Directors or trustees cannot vote by proxy.
A director or trustee who has a potential interest in any related party transaction must refuse from voting on the approval of the related party transaction. Presiding officer. Under RA 11232, it is now the chairman of the board or chairperson who is the designated presiding officer in board meetings. The president may preside over board meetings only when the chairperson is absent or unable to do so. The law provides that the pledger or mortgager is given the right to attend and vote based on such shares at said meetings of shareholders, unless the pledgee or mortgagee is expressly authorized to exercise this right in their stead.
Question. Danilo, a resident of Malolos, Bulacan, obtained a loan from the Rural Bank of Santa Rosa, Nueva Ecija, amounting to 90,000 pesos. The loan is secured by a pledge of shares of stock of St. Michael Corporation, covered by 3 stock certificates of 1,000 shares each. Which certificates are registered in the name of Servando, a friend of Danilo? The current market value of the shares based on the records of the Philippine Stock Exchange is 30 pesos per share. Other than the pledge of the shares, no other document or information is recorded in the books of St. Michael Corporation at its office in Pasig City. Who is entitled to vote the shares of stock in the stockholders' meeting? Whoever is the registrant. The pledger or the mortgagor are the ones who are entitled to vote. Remember that in case of mortgage or pledge, there is no transfer of ownership. Therefore, whoever is the registered owner of the shares, they are the ones who are entitled to vote. In this case, who is entitled to vote? Servando is entitled to vote.
The authority of executors, administrators, receivers, and other legal representatives to vote is by virtue of judicial authority, and this is even without a written proxy. In case of death of a stockholder, the heirs do not automatically become stockholders because there is still a need to settle the estate of the deceased stockholder.
What is our rule in case of joint ownership of shares of stock? Say we have certificate of stock. The shares are registered in the name of A and B in an end capacity. The rule is that the consent of all the co-owners shall be necessary unless there is a written proxy. This must be signed by all the co-owners, authorizing one or some of them or any other person to vote on their behalf. However, in case of shares of stock, say the certificate of stock is registered A or B in an or capacity. The rule is that any one of the joint owners can vote.
Proxy voting.
Manner of voting by proxy. This is only allowed in case of stockholders or members. The board of directors or trustees are not allowed to vote by proxy. When authorized in the bylaws or by majority vote of the board of directors, stockholders or members may also vote through remote communication or in absentia, provided that the votes are received before the corporation finishes the tally of votes. They shall be deemed present for purposes of quorum. The proxy shall be in writing, signed and filed by the stockholder or member in any form authorized in the bylaws, received by the corporate secretary within reasonable time before the scheduled meeting. The proxy is valid only for the meeting for which it is intended, unless it is continuing, which should not exceed a period of 5 years at any one time.
Voting Trust Agreement. Voting Trust Agreement is an agreement in writing whereby one or more stockholders of a corporation transfer their shares to a trustee or trustees for the purpose of conferring in the latter voting and other rights pertaining to such shares. This is to enable the stockholders to dispose their shares but still retain control over the corporation.
Let us have an illustration of VTA. Say that Anna owns shares of stock of APC Corporation. She would like to go to America, but is quite worried on her equity with APC Corporation. Alfred made an offer for the execution of what we call a voting trust agreement. In a voting trust agreement, the certificates of stock covered by the voting trust agreement shall be cancelled. New certificates shall be issued in the name of trustee, stating that they are issued pursuant to the VTA. In the books of the corporation, it shall be stated that the transfer in the name of the trustee is made pursuant to the VTA. The trustee shall execute and deliver to the transferor voting trust certificates, which shall be transferable in the same manner and with the same effect as certificate of stock. The voting trustee acquires legal title to the shares. The stockholders making the transfer become mere equitable owners of their shares, represented by the voting trust certificates. Accordingly, they are disqualified from being elected as directors unless they retain at least one share of stock in their name. The trustee votes in accordance with the terms of the VTA. He may vote in person or by proxy as provided therein. Both the transferor and the trustee may exercise the right of inspection of all corporate books and records. Any stockholder may inspect the voting trust agreement filed with the corporation in the same manner as all corporate books and records. Any other stockholder may transfer his shares to the same trustee upon the same terms and conditions stated in the voting trust agreement.
Requisites of VTA. VTA must be in writing and duly notarized. A certified true copy must be filed with the SEC, otherwise it is ineffective and unenforceable. The voting trust shall not exceed 5 years at any one time, except if it is specifically required under a loan agreement, in which case the period may be for more than 5 years, but shall automatically expire upon full payment of the loan. Unless the voting trust is renewed, all rights granted in the agreement shall automatically expire at the end of the agreed period, and the voting trust certificates and the certificates of stock issued in the name of the trustee shall be deemed cancelled, and new certificates of stock issued in the name of the transferors. No voting trust agreement shall be entered into to circumvent laws against monopolies and illegal combinations in restraint of trade or used for purposes of fraud.